Hi and welcome to the Lawdit Solicitors Podcast. I'm joined today by two solicitors, Izaz Ali and Sena Tokel, and I'm Owen, and I'm a trainee solicitor here at Lawdit. And today we're just going to be discussing quite briefly pre-action. So pre-action is where a client comes in and says, I have this issue or this has happened, what can I do? So usually at first instance we will kind of talk through with the client, gauge what the problem is, and find out all of the relevant facts in relation to that and get them to supply all of the documents for us to review. Then that's kind of the first instance. Upon reviewing the documents, what we would then do is give advice to the client on the best ways to proceed. Usually that starts with a letter before claim. So, Sena, would you like to briefly talk through?
Yeah. So as Owen explained, it's a letter before claim. It's also quite commonly known as a letter before action. Now, this is the general starting point that we always advise our clients to go ahead with prior to kind of, bypassing that and going straight to issuing a claim. Because quite often, not quite often, but sometimes you find that you can actually resolve these disputes without the need to issue claims, without the need to incur further legal costs, waste more time for both parties. So, a letter before action or a letter before claim is generally a good starting point. And it also goes hand in hand with the pre-action rules.
So what it's very important to note that when you start to looking at resolving a dispute, that's always a sort of first and foremost thing that should always be in your mind. We're guided by the civil procedure rules here, and the civil procedure rules do provide certain protocols to follow. There's protocols in relation to construction disputes, protocols in relation to personal injury claims, etc., etc. So the protocol is a format and the way that you go about doing things. So it's really, really important that you cover that off. And one of the sort of key things that Sena touched upon, which I think is really important, is that you must follow those protocols before you issue any claims, so you don't have cost consequences. And what I mean by that is that if you went straight for the jugular and you issue proceedings against a third party, they can then seek to recover their costs from the court on the basis that they weren't given or provided certain information at the outset, which you would have been obliged to have provided under those protocols.
And it's always more beneficial to see if you can exhaust all options and try and resolve any dispute before you kind of take instruction or advise solicitors and then issue kind of court proceedings. So we always try and suggest alternative means to kind of resolve issues.
Yeah, absolutely. And I mean, one of the key things that people often overlook, and that is that, and especially when you talk to people about the sort of level of damages that they could potentially recover or their losses, and that's something that we've touched upon previously to do with the remoteness of, reasonably foreseeable losses and damages. But another crucial one, which people often overlook, and that is the point of mitigation of losses and damage. So it's really, really important for you to be able to draw a line and say, right, what can I do to mitigate this loss or mitigate the damage? What can I do to, stop this happening? What can I do to, prevent this sort of escalating to a level where my claim against them is going to be, 10 times the amount I'm seeking to claim right now. So you're duty bound to actually do that. And it's important to have open and without prejudice correspondence. And with open correspondence, you would set out your stall, you would set out what the nature of the claim is, what the issues are, what you've done to resolve them, what you're seeking at claiming, what the sort of court costs are, what the duration will be, what the trial costs are likely to be. And all of that is designed to focus someone's mind to think, oh my God, this £15,000 claim is not small claims anymore. It's likely to result in, an outlay of another £15,000 in legal fees. Multiply that by 2 because there's 2 parties involved. So the potential outlay is 30k worth of exposure. And then the judge could easily award the 15,000. So someone looking at this, the loser, could be looking at paying £45,000. So that's just a really, really overview, a simplistic example I'm giving you. So alongside that open letter, you could issue what we call a without prejudice letter. And a without prejudice letter is usually said to be without prejudice, save as to costs. And we'll talk about that in a brief moment. But what we want to cover off in that without prejudice letter is right at the outset, is your offer. It's you extending a hand and saying, although I've got that claim against you for 15k, and if I'm confident I'm going to win, and if I went to court, it's, you are looking at a £45,000 payout there. If we can come to an arrangement, I'll give you the opportunity right now, right at the early stages, to settle this case with me, and I'll accept £11,000 payable within, say, 28 days, and we both walk away from one another. Neither you or I have to incur any further costs when we end this dispute, this full and final settlement. So it's an offer, and it's a without prejudice offer. But it's also a really, really important thing, because you can make a what we call a Civil Procedure Rules Part 36 offer, which is really, really powerful. What that basically means is that at the point of you making that offer, so it doesn't have to be necessarily just made at the outset, it can be made at virtually any stage of the litigation. But the importance of it is that once you've made that offer, if the other party does not accept that offer and they go to trial and then they lose at trial, then the without prejudice correspondence and the Part 36 offer then gets brought to the attention of the judge. And what the Part 36 offer effectively states is that from the point of us making that offer, if at final trial the other party does not beat that offer, so they get a lesser amount than what you'd offered them originally, then from that point onwards, all of the costs that you've incurred from the point of making that offer, you can recover from them. It's just a really powerful thing. So whenever we get clients that say that, well, look, I'm looking at potentially, I want to fight this, I want to do X, Y, Z, we say, well, look, have you considered this? And then we use our own skill set. We look at case law. We look at what damages have been awarded in similar circumstances. On occasion, we'll instruct specialist counsel to be able to advise on potential liability and damages that are likely to be awarded in a case like this. And then we can use that to structure and put together a really good Part 36 offer. And there's no harm in actually, when you put an offer together, to actually share some of your underlying material and say, as in the case of X, this was awarded, and in the case of Y, this was awarded, and this is why our offer to you is, for example, Z. And they can review that material and know that this appears to be a good offer. And we will struggle potentially to beat this. And as a result, we ought to take this and walk away from it. So it's really, really important to sort of look into that sort of aspects of litigation as well.
And just to confirm, with the Part 36 offers, you can quite literally put them in at any point. You could do this before you issue proceedings, or do you need to be at a stage where you've issued proceedings in order to set out the offer?
So very, very good question. It depends on the pre-action protocol and essentially what's happened in correspondence. So obviously what we would advise clients to do is have correspondence, engage in correspondence with the other side so that we can, continuously assess your case and work out the strengths and weaknesses of your case, ask the other side for disclosure, ask them for evidence, ask them for confirmation of X, Y, Z, so you can actually look at the case in a more rounded way. And then once you've got an idea of exactly where you are, then you can look at making a Part 36 offer. Now, for example, if you're heading into trial and then you put a Part 36 offer, but the other sides have already incurred their brief fee of instructing counsel, they've already reviewed all the documents and they're ready for trial, putting in a Part 36 offer at that point is kind of useless because they've already gone through, they've incurred all those costs. So it's difficult for you to be able to do something there, but it still doesn't detract from the fact that you can still make that offer because, they may lose that case. So it's you making a sensible offer. So yes, you can make it at any given stage, but you should think quite tactfully of when you do it. But always, if you can try to resolve a case, or what we would say is refine and whittle down the issues that you've got through correspondence, you can then put a claim together that's a lot more concise. Mm-hmm. So your particulars a claim, your claim form and particulars a claim are then quite precise as to what the nature of the dispute is, as opposed to sort of having a scattergun approach and having something drafted so widely that it'll take witness statements and further particulars and defences and, replies to the defence and counterclaims to, whittle down the issues.
Yeah, so narrow it down to the key issues before you kind of jump the gun and go straight ahead with a claim and, potentially shoot yourself in the foot.
Yeah. I mean, and just bear in mind the Limitation Act and limitations for when you need to file a claim. So if you're up against a deadline, you can approach the other side and seek consent with them to extend it. Sometimes you're up against a clock and you need to put a claim in just to protect your position, in which case, at that point, you would potentially have a scattergun approach to be able to cover off several issues before you can finalise and get to the bottom of them. Because then filing something outside of that period, you'd need permission from the court, leave of the court.
And back to the pre-action side of things. So let's say I receive a claim, and from a solicitor's on behalf of the claimant, and they've not provided for any, letters before claim, letters before action of any sort. I've just been hit with a claim. What could the repercussions be for the claimant for failing to carry out any pre-action?
Well, certainly when it comes to costs, this would be taken into consideration. So one of the points of their defence ought to be that we've received this claim from, we have had no notification of this, as in they've not communicated to us that they're going to issue a claim against us in respect of this.
They've not tried to settle.
Yeah, we've not had the opportunity to be able to air some of these points. And then in your defence, you would list the points of dispute, and then a final paragraph in there, you would say that we want to draw to the attention of the court that under the civil procedure rules, they didn't engage in X, Y, Z, and as a result, they ought to be penalised when it comes to the issue of costs. So that has a cost consequence on the claimant.
Also might be best to kind of look into the other options of resolving the dispute without the need for a claim, such as, and the courts quite encourage this at the moment, which is alternative dispute resolution methods, such as mediation and so on.
Yeah, absolutely. So yeah, I mean, I would totally agree with that. With regards to any aspect of any dispute, I think court should be your last resort, and you can kind of engineer a case in the sense that if you can show that the parties have engaged with one another, or for example the claimant's really reached out to the defendant and really attempted to resolve a dispute, but the defendant's not engaging or has not been forthcoming, and you want to show the court that, look, we've come to you at the last resort, we're really up against a wall, we need help, these are the wrongs that the defendant's committed, and this is we've attempted to work with them to put things right, but they've clearly not engaged, they're not interested, and this is why we are here now before the court, and that obviously stands you in good stead.
Yeah, because it's the court's aim to be kind of the final resort, the last kind of option to resolve the dispute between the parties. They would really prefer if people could settle it outside or come to an agreement beforehand.
Yeah, absolutely. And there's so much opportunity available in terms of engaging in mediation and arbitration, etc. And it's always something that the court would actively engage parties to do. So I think it's really, really important if someone's in any sort of dispute that they do actually reach out, engage with a lawyer and ask for advice and assistance with regards to a particular dispute, and actually say that, look, I'm open to any form of mediation or arbitration, alternative dispute resolution, to try to get this resolved without incurring significant court time and costs, etc.
That's exactly what I was going to add to that. I said quite often you find that people who do decide to engage in alternative dispute resolution can save on significant costs, both legal costs and personal costs, as well as time and stress. Why pursue a matter and go all the way to the end when, you could have resolved it before having to go through the trouble. And like you said, wasting the court's time as well and adding to pressure to everything else.
Yeah, because litigation is costly. And at the end of the day, it's just a fact that when it comes to litigation, it's the lawyers and the professional advisors and the experts that are engaged that will all make money from the situation. So the warring parties, there'll be a winner and there'll be a loser unless we can reach some sort of compromise. And that's what it's all about. Litigation is about compromise. It's an expensive process. And if someone can sort of reach out and try to resolve things, was always encouraged. Mm-hmm. So we'll do a follow-up podcast. It's very, very interesting to go through that. We'll look at something to do in relation to an actual claim and what have you. So Sena, it'd be good to have you back on a podcast in relation to that in the very near future.
Definitely a topic that we ought to explore.
Thank you for listening. And if you have any issues that you feel like you need our assistance with, then please feel free to contact us.
Thank you.
Thank you.